Welcome, everybody. I'm Courtney Mercer, the Executive Director of Downtown New Jersey. We are excited to have two partners from Greenbaum Rowe, Smith and Davis, who are wonderful supporters of Downtown New Jersey, to speak with us today about the new cannabis law. They're going to approach it we have two speakers because we have two different approaches. Steve is going to talk about what it means to the municipality from a zoning land use perspective. And then Jemmy is going to speak more to from a workforce perspective and what it means for employers dealing with employees under this new law. Real quick, a little bit about Downtown New Jersey. I think most of you know us, but we are a nonprofit education and advocacy organization. We are a member-supported nonprofit with our member support. We provide education, advocacy, and recognition for New Jersey's downtowns and in support of their revitalization. We've been holding these forums since right after the shutdown last March. We've done about 25 so far. There are recordings up on our website for most of them, written summaries for the early ones. We have two more coming up. We won't be doing one in August, but in July, we are doing a forum with Melanie Willoughby of the New Jersey Business Action Center about the plastics and styrofoam ban. And then in September, we'll come back and we'll do a brownfield forum. So we hope you will join us for those future forums as well. And feel free to check out our website to get information about past forums. So without further ado, I'm going to stop screen sharing so Stephen can tell us what's what.
All right. Well, thank you for having us on this beautiful Friday day. I just want to start off by saying many of you knew him, but those of you didn't, Michael Fabrizio, who was a longtime fixture in downtowns, especially Morristown, and was the head of the SID there for more than 20 years, most recently the head of the parking authority there, but was also in charge when Morristown went to the Supreme Court in '99 and had the Second Rock case come down, which is obviously the most seminal case that most of us deal with that work in and around downtowns. He suddenly and tragically passed this week. So we remember him and all that he's contributed to New Jersey downtowns in his life and career. So today we are talking about marijuana and cannabis. And I think much of this is already known, but we're going to approach it as was said from two different angles. I'm going to talk a little bit about from the municipal side, from the land use side, how the bill impacts municipalities, and then we're going to toss it to my partner Jemmy, who's going to talk about it from an employment perspective. So just a little overview. We all know that this went on the ballot last year and was supported by New Jersey citizens in an overwhelming majority. And then earlier this year, there were a number of bills that were adopted and signed by the legislature, but the key one that I'm going to be talking about, and I'm going to take a deep breath here, the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act was adopted earlier this year and sets forth basically the framework for the licensure of adult recreation use marijuana. Just a couple of basics about the bill, and then we'll dive into it. The basics are that now the possession and the purchase of up to 6 ounces of marijuana is legal for adults 21 and older. Those who possess more in that quantity are going to have lessened criminal penalties. And then for minors that are caught with it, there's actually a series of warnings before there's any enforcement that takes place. The bill creates a Cannabis Regulatory Commission, which is a 5-member commission that is tasked with developing regulations regarding all aspects of the licensure and operation of cannabis businesses. And the law provides that commission must adopt rules and regulations by no later than August 22nd, 2021. Remember that date now, August 22nd. Commission's going to, after the regulations are adopted, they're going to be in charge of licensing all the new businesses and then overseeing those licenses. So it's an important commission that has been created. What's also been created is 6 different class of licenses. So there's 6 different types of businesses that can be regulated now in the cannabis space. Class 1 is cultivation. These are your growers and your producers of the plant. These are your farmers. They can sell to others except for consumers. Class 2 are your manufacturers. These are the people that are going to use the marijuana that's been grown and produce cannabis related items. Likewise, they are able to sell to anybody except for direct consumers. Your third class are your wholesalers. They can purchase, store, and sell cannabis in bulk, either to distributors or to retailers. Class 4 is your distributors. And really what they are is they're the delivery vehicles. This is a license that is going to allow them to transport intrastate. They cannot cross state borders for obvious reasons. It's still illegal at the federal level, but they can transport in-state between licensed businesses. Class 5, and the class we're going to be talking most about today, are your retail licenses. These are the businesses that are allowed to purchase either directly from the farmers, the cultivators, the manufacturers, or the wholesalers, and then sell direct to consumers. Now, a note about the retailers is the law already, without any further municipal ordinances providing this, already prohibits these locations in grocery stores, delis, indoor food markets, or other retail food establishments, or any place that has a liquor license. So these retail locations cannot be located in any of those facilities. And then your sixth class is your delivery license. These are licensees that are able to accept orders from the consumer and have the products delivered direct to the doorstep. Municipal ordinances they're prohibited from prohibiting the delivery of cannabis items. So we're going to talk a little bit about the powers that municipalities have to opt out of the use of some of these classes. One thing they're not allowed to opt out of is allowing the delivery of cannabis items within their borders. So when I mentioned opt-in, opt-out. Municipalities have been given 180 days, August 22nd, 2021. So the same date that the new commission is supposed to come out with rules and regulations, municipalities have until that date to choose to either opt in or opt out. And what that means is if they want to opt out, they can choose to opt out of either one or all of the classes of licensees that take place within their borders. However, if they choose not to do anything, they don't opt in or they don't opt out by August 22nd, the law will automatically assume that they opted into all classes. That is going to stay in place for 5 years. So if a municipality decides to opt in or does nothing, so it's automatically opted in, the earliest that they would be able to opt out again in the future is 5 years from August 22nd, 2021. On the flip side, if a municipality decides to opt out by August 22nd, they can choose to opt back in at any time. So it's not reciprocal. So again, municipality opts in, they cannot opt out for 5 years, but if they opt out, they can opt back in anytime. So why this is important, and when what we're seeing in a lot of the municipalities that we're involved in is this competing interest between wanting to provide a comprehensive zoning plan or regulations if they decide to opt in that meets the needs of their citizens and their businesses, with the reality that there are no regulations yet. There are not going to be regulations probably until right before that deadline, because that's the same deadline that the commission has to adopt their regulations. So municipalities are facing this decision of, well, do we opt in without knowing what the regulations are going to allow us to do? Or do we opt out knowing that we're allowed to opt back in at any time, including a month after the regulations come out if they want to? So for many towns, the most recent one I was privy to was Westfield. We represent them as the redevelopment council. They put together a cannabis commission to go through these issues, and the ultimate conclusion of that commission was there's just not enough information now. We don't know what the regulations are going to say that are going to allow us, to have our own regulations. And if we opt in blindly, we're going to be stuck for 5 years. Whereas if we opt out, we can always opt back in. So that's the struggle a lot of municipalities are facing. Again, in 5 years, a new window will open up. A new 180-day window will open up. So for those municipalities who opt in and then 5 years down the road decide it wasn't working and they want to opt out, then the window will open every 5 years and then 5 years thereafter. However, existing businesses that are licensed and allowed to open up in a municipality during an opt-in period, they're going to be grandfathered in perpetuity, even if the municipality later decides to opt out. So let's talk a little bit about the taxes. What can a municipality do? Well, if they do opt in, they're allowed to impose local taxes, up to 2% tax on cultivation, manufacture, and retail, and 1% on your wholesalers. It doesn't have to be that amount. It could be less than that, but those are your caps. They're paid directly to the municipality from the business, and the municipality can establish by ordinance how it's paid, monthly, quarterly, by ordinance. Now, if the municipality does opt in, the law is going to allow for standard land use type regulations, hours of operation, what zones it's going to be permitted in, some design standards, and things like that, the number of businesses within town. But that's as bare bones as the law currently says. There's expected to be more detailed regulations coming from the commission, which is what leads to many municipalities struggle in deciding what to do here. Now, after the regulations are adopted, there's going to be what the law calls a transition period. It's a 24-month period during which time there's going to be applications for licensure, there's going to be processing of those applications, and it's not expected that retail shops are going to be able to start selling to consumers until well into 2022, if not creeping into 2023. So to make up for that, what the law does is that any existing medicinal facility that's licensed during that transition period is going to be able to start selling recreational products during that transitional period. And then the last thing I'll mention is it's been tossed around in a couple of the meetings I've been in involving this, is that the final version of the bill that was adopted prohibits individuals from growing their own cannabis for personal use. There were a number of versions that went out, and some versions did allow it, some versions didn't. So there's some misconception about that. So I figured I'd mention the version that did pass does not permit the personal growing of cannabis. So that's really my little piece on the municipal impact from the bill. And I think we'll turn it over to Jemmy now, and then we'll entertain questions on both sides afterwards. But thank you.
Thank you, Steve. Okay, everyone. Well, welcome. So I'm going to handle the sort of the employment side of things, and I'm going to go ahead and share a PowerPoint presentation that I put together, and because there's a lot of ground to cover, and I don't mind circulating this after the fact if it goes a bit too fast. But Steve, as you obviously just heard from, gave you the how we got here. So there was you see it right here on November 3rd of the state election, public question number 1, New Jersey's population overwhelmingly voted in favor of the referendum and New Jersey constitutional amendment to allow for the legalization of the recreational use of marijuana, obviously subject to many, many considerations. So February 22nd of this year was signed into law, and this is for recreational use for individuals 21 years of old and older. As we know, there's a history to all of this. New Jersey, this isn't the first foray that New Jersey made into the world of cannabis. The Compassionate Use CUMA, that act, which was for medicinal marijuana for certain individuals, was passed back in 2010. Then it was expanded in 2019 with the Jake Honig Compassionate Use Medical Cannabis Act. And that had some increased and fairly robust provisions regarding obligations of employers, and specifically what employers can and cannot do when they suspect or actually have confirmation that somebody in their employ has used medicinal marijuana and there's been some sort of an issue. Then we see obviously the results of the 2020 election, and we get dumped into the world of CREMA. As Steve already said, the very long name of it, I won't do it for you. So what I'm going to do today is just go through some of the significant implications for both employers in terms of their rights, and then what the employees' rights are and how employers should make sure to deal with those issues. Okay, so obviously, there's certain things that don't change. Employers can still maintain and enforce drug-free workplace policies. This is, nobody is saying that everyone can come to work and engage in the use of marijuana while performing their function. That is certainly not something that is permitted. And the drug-free workplace prohibits use, possession, or being under the influence of marijuana in the workplace and during work hours. Now, just going back to that, obviously, clearly it makes sense being under the influence, but even possession is something that is, something that can be strictly enforced. So that's, that might become a gray area. People bring with them a pen or something like that that they intend to use after work, and that might be something that you come across. So, things to be mindful of. Employers are not required to permit or accommodate the use, consumption, being under the influence, possession, transfer of cannabis or cannabis items in the workplace, or to affect the ability of employers to have policies prohibiting use. So there's nothing that says that you have to accommodate the use of marijuana during work, even if that's something that, and this probably deals a little bit more with individuals who might need it for purposes of medicinal use, but you certainly do not need to allow somebody to be high at work, even if it's for purposes of dealing with some sort of an ailment. And candidly, that's no different than, you wouldn't want somebody who might be in a position to, say, drive a, forklift or something like that to be under the influence of OxyContin or codeine while they're on the job. So a lot of these things are very logical. There's also a carve out under CREMA for federal contractors. It's still, and we're anticipating some continued evolution on this as we have a new administration, but marijuana is still technically a Schedule I drug under the Federal Controlled Substances Act. Now, obviously, there are mandates that come out of Washington, the Office of the Attorney General, both on the state and federal level, even before the decriminalization, that basically told law enforcement, don't go overboard. This is not something that we need to expend a tremendous amount of resources on. But again, it's still technically on the federal level a Schedule I prohibited drug under the Controlled Substances Act. Moving on in terms of some employees' rights and what employers need to be mindful of. So employers can't take an adverse employment action because they believe that somebody is engaged in the legal, and this is obviously subject to the regs that are going to come down, but they can't take adverse employment action when somebody is, they know that after hours and outside the workplace, they use cannabis or cannabis item. And, adverse employment action is something that we hear. I'm an employment litigator as well as a commercial litigator. My whole life circles around the world, my professional life, around what an adverse employment action is. And obviously, everybody knows the fundamentals. Firing somebody, you find out that they after hours are, using marijuana, you decide to fire them. Obviously, that would be an adverse employment action. But there's a lot that falls within that umbrella. Refusing to hire somebody or employ them once employed, so that would be termination. Barring or discharging an individual from employment, and this is all contained within the Act. Requiring an individual to retire from employment, or discriminating against an individual in compensation or in any terms, conditions, or privileges of employment. For example, you decide to send them to the less favorable route, one that is more rural than, suburban, because you don't, you're suspicious that they may not be as good of a driver, things like that, where you decide to change the terms of their employment, purely based on the fact that they engaged in what would be a protected activity outside of work. Also, employers may not make an employment decision solely based on an arrest, charge, conviction, or adjudication of delinquency for violation of certain state laws related to cannabis. Now that, obviously there's a lot that goes into it. If the position is something where you have to have somebody, in a protected sort of capacity, they're driving, they're going to be dealing with, particularly vulnerable individuals. All of this is very case specific, but under the law itself, you can't make a decision solely based on that fact. And that could subject an employer to a potential fine of up to $10,000 per violation. So nothing to sneeze at. Another significant implication is that these prohibitions apply to all employees, regardless of job classification, nature of job duties and responsibilities, and including those that work in safety-sensitive job positions. Sorry, I keep clicking and it keeps forwarding. That just means that, again, you just have to be very careful when considering any sort of adverse action against somebody based on any use of marijuana. Essentially now legal marijuana users are afforded protected class status under the New Jersey law. And this may seem somewhat overly progressive, but it's not really that different than any other, afforded right that an individual might have. You can't discriminate against them or take adverse action based on something that they lawfully do outside of work. Okay, some more significant implications deal with drug testing. And this is an evolving issue. It's something we've been looking at for years, but in terms of, now under CREMA, it's drug testing still permitted if, and this is, there's a lot here. If the employer reasonably suspects that the employee's usage of a cannabis item that they reasonably believe that while engaged in the performance of the employee's work responsibility. There are observable signs of intoxication related to usage of a cannabis item. The drug test follows a work-related accident subject to investigation by the employer, or the employer conducts random drug testing, requires drug testing as part of pre-employment screening, or requires drug testing as part of regular screening of employees to determine use during work hours. And what I would say, and we'll get into this a bit more, but numbers 1 and 2, you have more exposure to possible, just claims by an employee that they were improperly treated if in fact they were not under the use of or the influence of marijuana. The second 2, if there's a workplace accident or it's part of a random program, are your safer bets. Because the reality is that, these things, and we're going to get to this, not everybody's an expert on what somebody under the influence of cannabis is. They obviously, people see the movies, there's some, general common knowledge as to what people tend to act like, but it's always risky when you assume that somebody is under the influence. And then, if you test them and it's negative, then you might open yourself up to, well, what were they doing? Is this really fair? Were you just targeting them? Is this some sort of retaliation? And obviously there's going to be more guidance on these issues when the regs come out in August, hopefully. But, again, this is sort of where we're focusing our attention and just what employers are going to be expected to do in these instances. Again, I'm probably going ahead of myself, but drug testing considerations. It prohibits an employer from taking an adverse action against an employee based solely on the presence of a cannabinoid metabolites in the employee's bodily fluids. Because again, marijuana as compared to, say, alcohol, it's not a clear indicator based on tests. You can't give somebody a breathalyzer and be able to tell to the extent that they're intoxicated when it comes to marijuana. Somebody could have permissibly used marijuana the night before and it's still in their system. We've heard this, it's in your hair, it's in, things like that. Certainly the science is advancing in terms of being able to test, but we're certainly not at a point where it's highly accurate. And again, you want to be careful to not take adverse action based on presumption. Employers must utilize the 2-part drug test, including 1, scientifically reliable objective testing methods and procedures, such as blood, urine, and saliva, and a physical examination, or evaluation, conducted by an individual with necessary certification to opine on the employee's state of impairment or lack thereof. And candidly, number 2 is going to be interesting. And I forgot the number 2, but because, the commission is going to come out with actual guidelines as to how one becomes certified. So as we know, and as Steve spoke to, the Cannabis Regulatory Commission has been formed. The last member was impaneled back in March. And so they have until August 21st. Steve, did you say August 22nd or 21st?
I thought it was the 22nd. If it's 21st,
so maybe it's deadline. They have until August 21st, and then it has to be effective as of August 22nd to roll out the regs. And so the employer-related provisions of CREMA are not technically operative until the regulations are issued, which again puts us in this lovely gray area, as it seems a lot of these provisions find ourselves in. But the reality is going to be how the regulations are going to deal with these types of issues when somebody is suspected of using marijuana. And there hasn't been a demonstrable, accident. They were driving the forklift. I mean, one of the seminal cases in New Jersey with medicinal marijuana was somebody was operating a forklift. They got into an accident. They tested positive. And their argument was whether or not they had been permissibly using it, not during work, but the night before, pursuant to medicinal marijuana license. Again, this Cannabis Regulatory Commission is going to establish standards in regulation for a workplace impairment recognition expert. That's what we talked about, prong 2 of the testing, and what it takes to be certified, to be issued to full or part-time employees or others contracted to perform services on behalf of an employer based on education and training in detecting and identifying an employee's usage of or impairment from a cannabis item or other intoxicating substances, and for assisting in the investigation of workplace accidents. So now the interesting thing is going to be, obviously not all employers, certainly not a small municipality or whatever, going to be able to employ a full-time individual to work solely on this issue. They can certainly designate an individual to take on these responsibilities, but it's anticipated that there might be some sort of outside service provider that might do this. Although again, how would that person be queued up in, quickly enough to investigate a situation when obviously whether or not somebody is under the influence is going to change as time goes by. If the accident happens at 10 a.m., if you have a situation where the person cannot be observed for some period of time, that could cause an issue. So we're very interested to see where the regs come down in terms of the who, what, when, where, and how of these wires. Okay, I think this is, this is my last slide. I know I'm sort of rushing through this, but happy to answer questions afterwards, as is Steve. From my perspective, obviously my space is HR, but also litigation as to HR. And so what we always caution our clients to do is always be careful of those sort of red flags you might see when you're dealing with a situation that could expose you to litigation going forward. And when we talk about a private right of action, that means the employee can't sue under CREMA. There's no law. The CREMA is not something where you say, I'm bringing a lawsuit under CREMA that you violated my employer testing right or employee testing rights. As of now, there's no, you cannot actually sue under the law. But what you can sue under in New Jersey is common law unlawful retaliation claims and New Jersey's incredibly robust and very progressive Conscientious Employee Protection Act, CEPA. And that's the Whistleblowing Act in New Jersey. Typical example of a whistleblowing claim under CEPA. Somebody at a chemical company calls and reports that they believe that the company has been dumping chemicals into a river. And they call and they make issue or they raise it to management, because you can do it internally or outside, to the government agency. Employer finds out about it, decides to fire the person. Claims it was for a legitimate business reason, but it turns out and the a jury could find that it was in retaliation for engaging in that protected act, that blowing of the whistle, that something illegal was going on. So you always have to be careful in dealing with employees and voicing, anytime they might be voicing some sort of concern or they're raising an issue and there's a perception that there was retaliation, like we talked about these adverse employment actions. You always want your tentacles to go up and make sure that you're dealing with that appropriately. Obviously, we always encourage you to consult with counsel, especially if you're going to be firing somebody, because that's always a tricky area. And as long as you've dotted your I's and crossed your T's properly, you can put in place certain measures to protect yourself, but nothing is ever foolproof. So best measures are critical. Obviously, we're going to also know more about the drug testing issue, but when in doubt, it's always a good idea to vet your system and make sure that you're not overly exposing yourself to potential liability. As we said, consult with counsel prior to a significant potential adverse action. Make sure your training is in place. Make sure your personnel and your managers know what to do in a situation, who to contact, how to document things, how to make notes in personnel files if you suspect that somebody is under the influence, but make sure you're doing so appropriately. And that goes hand in hand with making sure that your HR policies are up to date, making sure that your handbooks are up to date, that you have clearly articulated expectations of privacy and things like that for your workforce. And then last but not least, as Steve forecasted, we expect a lot more movement once these regs come out in August. And, we'll be, maybe we can do this again because we'll be diving into those to see exactly how employers need to be modifying their procedures, and certainly from the standpoint of everything Steve discussed. So with all of that, I'm going to go ahead and stop sharing so that we can see all of you, and open the floor up to questions for either Steve or I.
I have a question for Steve. It's Michael Parlavecchio.
Hi, Michael.
Steve, hi. I had a question about the Class 6 delivery license. Can a municipality opt out from issuing the Class 6 license with the understanding that it can't prohibit an otherwise licensed courier, for lack of a better word, who's licensed in another town? So if an adjacent town has Class 6 licenses and they want to come deliver in your municipality, do you still have to issue those licenses yourself? Or do you have no choice on the opt-in, opt-out on Class 6?
No, you don't have a choice in that. The choices you have to opt out of would be the cultivation, the manufacture, the distribution, and the retail. Not the distribution. The distribution and the delivery are the two that cannot be opted out because they're really they cross borders. Now you can opt out of a facility that would be located if what I would imagine is that there's going to be very few businesses that are just delivery class, right? They're going to be combined with another class that's probably going to be a brick and mortar location somewhere. So you can obviously opt out of those type class businesses within your borders, but delivery and distribution are not able to be opted out.
Thank you.
I have a question for Jimmy.
Sure. Hello.
Hi. Just some clarification on random drug testing. Is there, as an employer, is there anything that would preclude me from implementing random drug testing and just across the board prohibiting use? Meaning, is there any, I want to make sure there's no conflict between what is permitted in personal use and what I might be implementing as an employer in terms of random testing.
So no, you can certainly have random testing as long as it's equal across the board, at certain, everybody is tested and whatever. The problem, obviously, as we indicated, is that marijuana is this, anomaly. I mean, it reminds me of back in science class with the half-life, and it's still in your system and whatever. So the question becomes, you're going to run a drug test of somebody. They're going to possibly show that they have marijuana in their system. And then what do you do with that? Do you say, can you confirm, can you sign a certification that says that you're not using this in the workplace? And I think the regs are probably going to, shed light on that issue, because unless somebody both tests positive and also is, showing indicia that they are under the influence, I would be very cautious in taking any sort of adverse employment action. What I would say, though, is that if you're going to do the random drug testing and somebody tests positive for use of marijuana, and then you make note of that, and then there's an issue down the line, for example, where there is an accident or something happens, then at least you can, if they test positive again at that point, it's a sort of indication of perhaps some sort of pattern of being under the influence. But those individuals who are going to be trained as to how to tell whether somebody is under the influence of marijuana and not just has it in their system, I think that's going to be of value.
Well, just a quick follow up to that. We in my business we operate outdoor sanitation and public safety personnel. We put them on the street, and we operate heavy equipment. We drive sanitation trucks. My insurance carriers hold me to a very high standard. At what point do I have to be able to demonstrate that I'm doing everything that I can to make sure that that we have all the proper testing in place? Like, for instance, anybody that drives our vehicles, they have to be approved by our insurance company. And I'm just curious, has there been much interaction between the state and large insurance carriers on what all this will look like, and what are there any more standards that insurance companies might put in place because insurance companies, I mean, they do everything they possibly can to get out of covering claims, and they hold us to a very high standard. And I'm just curious, I haven't heard much about how insurance companies, from a human resources perspective, how they're responding to all of this new action that's being taken around the country.
So I think that you just hit the nail on the head by saying all these different approaches being taken around the country. There's 50 states, and there's, runs the gamut from absolutely no permissible use of marijuana, neither medicinal nor recreational, to several states now that, have allowed for both. I am certainly not an authority on insurance coverage, but I have not seen anything really fully developed on this issue yet. I think that it's going to certainly start coming out very quickly after these regulations are passed, and there is some sort of way to gauge whether or not an individual is appropriate for termination based on a positive, test, and then also companion demonstrable indicia of being under the influence. Obviously, to your point, I mean, that's why I think they carve out the federal, a federal contractor who, is subject to federal laws that say that marijuana is still a controlled dangerous substance. You don't have to allow any. If you're a federal contractor, any positive test, that's still grounds for termination because they're working for a federal contractor. Unfortunately, this is such a gray area. Everybody's heads are spinning. Steve, if you have any insight on this, please jump in. But unfortunately, I think we're in that horrible gray area where we're going to see what comes out. And then there's going to be a lot of lobbying that's going to go on, both on certainly the state level. And I wouldn't be surprised under this administration if we see it on the federal level, sooner rather than later. So I know that was a very long non-answer, but unfortunately, this is just, I would always caution you, though, to make it very clear to your employees that, certainly anyone coming to the workplace under the influence of any, of marijuana, notwithstanding that it is, legal in the state as will be defined by the regs, is impermissible, just to put them on notice and make sure and reinforce the safety sensitive nature of the position.
Yeah.
Jeremy, notwithstanding waiting for the regulations on the marijuana, random drug testing has been around before then for other things.
Of course.
And I think something that's important for employers to know is that there's got to be, and you can probably speak to this better than I am, whatever their procedures are for the random drug testing that is in place need to be followed to ensure that it's not going to result in other discriminatory claims.
Well, and that's my point, but that's part of my point. We're kind of putting employers, and especially employers like me, where we have, over 100 people out there operating equipment, driving vehicles. You're kind of, not you, but these new regulations, kind of putting employers like me in a position where, without fail, we have to have across the board random drug testing in place. We essentially have to prohibit, we have to prohibit usage through random drug testing, because there's no way for us to really protect our exposure here. I mean, the last thing that I want to do is get into a back and forth with employees on, when did they last use a substance? I don't want to get into that back and forth. I want to just prohibit it across the board to ensure that my people are, you know, are not putting me at risk. And so it kind of, you know, these new regulations sort of put us in a position where we have to do that.
But I don't think legally, unless you're a federal contractor, you can prohibit your employees from using recreational, you know, from the out of work recreational use of marijuana, because it's now legal.
Sure.
So if you're going, so to your point, you're sort of backdooring suggestion that they not partake, right? Like you're basically saying, but at the end of the day, you're certainly going to be faced with somebody who's going to test positive. And then the question becomes, what are you going to do with that person? You know, if they don't simultaneously give you a sense that they are not performing their duties appropriately, or that they're driving around high and at risk of you know, getting into an accident, and then insurance is invoked, and then they might disclaim coverage, you know, that's the problem.
Yeah, I think that there should be some consideration. This obviously goes beyond this discussion today, but there should be some consideration to expanding. So the federal
Contractor
accommodation
provision, right.
here, there should be some consideration to expanding that to include other industries where heavy equipment is used and things of that nature. It would make it a lot easier for employers like myself.
I completely agree with you, but the reality is probably that it's going to go the other way, and that on the federal level, it's going to become legal. Again, I don't have a crystal ball, but if I just had to guess based on the current administration and sort of some of the policies that have come out, it's more likely than not that on the federal level, you know, marijuana will be declassified and at least removed from Schedule 1 status. So it's more likely, you know, and then I have to imagine whether it's on the federal or state level, there will be regulations put in place to at least give some additional guidance to employers as to how to navigate this gray area. And I get it, because it's not like alcohol. You can't give somebody a breathalyzer. I'm hoping that the science gets better. But then again, that all speaks to, you know, I mean, blood alcohol level, fortunately, is fairly accurate, because no matter what your tolerance is, it's sort of your body's ability to metabolize, you know, alcohol in your system. And so, you know, all I would do, in certainly not giving legal advice, but just cautioning you that, yes, you can make it very clear. This is, you know, these positions need to be taken very seriously. But, you know, you have to be ready if you're going to do the random drug testing, that you're going to get people who are going to be positive. And it's not like it's a show me your medicinal marijuana card, I know you have, you know, back problems or whatever. This is going to be, you know, you really can't take that hardline position, although you may want to.
Yep.
Vic very politely has his hand raised.
I did not see that.
No, yeah.
Sorry.
No, that's okay.
Oh,
Go ahead.
that. Okay. The virtual hand. Got it.
So thank you. Steve, I have a question. I have two questions for you. One is, I'm a township committeeman in Maplewood. And one is a broad question. I've heard some legal thoughts that it's not so easy to opt out now and then opt in at any time after August 22nd. Wonder if you have anything on that. And the second thing is, you mentioned the medical ATCs that exist, and we have one in town, Termination, New Jersey, that they're grandfathered in. So could you talk a little bit about that?
So as to your first question, I'm not sure, we can look into it. I'm not sure what the thought on why it would be difficult to opt back in. The way the law is structured is pretty clear that entities, municipal corporations that opt out can opt back in at any time, that there's no time constraint. So as to what aspect of it makes it difficult, I'm not entirely sure. My involvement in many towns wrestling with this decision has been that narrative that if they opt out, they shouldn't have a problem being able to opt back in once the regulations are clear in terms of what they're able to do with the regulations, their own local regulations. Now, with respect to your second question, which was you have an ATC in your town, is that what you're saying?
Correct.
And what was the question about it?
So the question is, you mentioned that they're grandfathered in.
Well, they're still licensed and they're operating now under already existing laws and regulations governing their licensure. What I referenced was that there's this official period that they refer to as a transition period. It's a 24-month period that starts once the regulations come out and the applications for licensing for personal use marijuana is available. So we're expecting that at the end of August, right? That 24-month period, during that period, existing medical marijuana facilities can operate in that personal use market, but they have to meet various certain conditions. It's not an automatic thing, and it's nuanced. So we can, I'd be happy to send you those sections of the existing law, but again, those are going to be dictated by regulations that are coming out. But there's an expectation that those existing facilities, once they meet those additional criteria, will be able to operate in the personal space during that period.
Just a quick clarification, Stephen, before we get to, I think it was Jason and then Bonnie. If a town opts out, but they have one of those medical dispensaries, can that medical dispensary still do the recreational, or are they prohibited because the town has opted out? Which is a little bit, weird for a town to say yes, medical and no recreational, but
It would be, I imagine it would be an odd circumstance, but I believe if you opt out, then you're opting out for across the border. So that would include that facility, but I can follow up on that and confirm.
Yeah. Jason, you were next.
Thanks, Courtney, and thanks Downtown New Jersey for putting this together, and the speakers was very informative. Figured it'd be good to piggyback on Mr. DeLuca's question. So I'm a council person in Metuchen. We are working through what we're going to end up doing. And one of the things I wanted to hear, and I've read it a bunch of times, and I've heard it from others, and you said it again, Steve, was if we opt out, we can opt back in at any time. So that's why I came here. I wanted to hear that one more time. So thank you for that. But my question really is around when I'm thinking through, what the Cannabis Commission is what rules they may come out with. I'm having a tough time imagining what would change anything for us here. Do you have any sense of the types of rules we might see, or how it might affect municipalities at all?
Well, I think it's foreseeable that we're going to get some specific regulations in terms of what control a municipality will have in terms of being able to further regulate the use from either a zoning perspective or an operational perspective. The law as it's written, it's really, really bare in terms of what a municipality's rights are in terms of those further regulations. It does allow a municipality to have some regulatory and zoning responsibility, but it doesn't get into the specifics that have been really reserved for the commission to set forth. So I think from the municipal side, that's really what I'm looking for, and hoping there's going to be some clarity. But I'm sure there's just as much unknowns from Jemmy's world with respect to the employment.
Okay, thank you. Yeah, it certainly seems like the prudent thing to do, especially with that ability to opt back in. So for the time being, so we're looking forward to see what they come out with and how fast we can act afterwards. Thank you.
Thanks. Bonnie's next, and I think I saw Chris wanted to come back in too. Go ahead, Bonnie.
I guess it kind of adding on to Jason, it's kind of when you read the legislation, what do we do as a town? What does the licensing program do? One example is the micro business. Do we limit? Do we require? They're required to give, I think, 25% of the licenses to micro businesses. So how do we do that with zoning, or can we, or do we have our own licensing program? I think some towns have done that for the medical, or they have a vetting program anyway. But another question is also, when you mentioned the food and the liquor license, does that mean on the same lot? Like if there's a multi-unit building, a strip mall, if you have a grocery store, can you not have a retail facility? Because Bloomfield, I'm from Bloomfield, we're going to probably be doing the retail option to opt in. And I'm just curious about that piece of the legislation.
Yeah, so I'll pull it up and I'll read that section for you here. Let's see.
I think it says on premises. So that, does that mean, yeah, it feels funny. And then also I think They're not allowed on properties that have pilots with the town. Is that accurate? Yeah. Okay.
Probably. There has been, as many of you know, dealing in this space, a great shift, many pieces of legislation over the last year that are really cracking down on what they perceive to be an abuse of the pilot structure. I would disagree with that, but you are seeing it tossed into bills that have no place being, and this would be one of them. So that's correct on the pilot.
Although, but is it, here's the weird thing, is it past pilots or is it moving forward? Because not knowing that this was happening, and then, you know, you have an empty storefront.
Yeah, I haven't heard any interpretation that it's existing.
Okay. Yeah.
That's perspective.
Right. So I think you're good on buildings that, you know, are in a pilot, but just going forward, they won't.
Oh, well, that's good. That's different.
Although we'll have to see what the regs
Who
say, right?
knows?
Again, there's no finality to any of the, you know, the interpretation of this law until you see the regulations really.
Right.
Yeah.
Thank you.
And what's this food thing? Steve, you were looking that up.
Oh, are you referring to what they're calling the cannabis consumption area? Which are
No, no, not that. It can't be where grocery stores, delis, liquor licenses.
Oh, the retail establishments.
Yes.
All right.
So
I looked up the wrong thing then. I'm sorry. We can go to the next question. I can have it. I can do a control F of this very large bill and get the exact language while we're getting to the next question.
So Chris, I think you had a follow-up.
Yeah, and Steve, this is actually for you, and also, you know, the elected officials that we have on here today. Steve, in terms of recreational use, right, and the now the accommodation that's been made for below 6 ounces in terms of possession, what do you anticipate the environment to look like in terms of like public spaces and parks? Will municipalities be left to regulate that in the same way that they regulate, let's say, the use of alcohol? Is that what that's going to look like? Because we've now allowed people to carry marijuana under this, a certain amount of marijuana on them, right? And so I guess that's one question. And then my question for the elected officials that are here today is, to what extent have you contemplated what that might mean, both for your policies, but also for your police department? I manage a number of public spaces throughout the state, and one of the biggest challenges that we have is helping local municipalities enforce prohibited activities like alcohol use. I can't imagine what it's going to be like now that once you add marijuana use to that, and then all the other factors that come into play. For instance, secondhand smoke. How are my rights protected as somebody that wants to utilize a public space when there's secondhand marijuana smoke being spread around, and I'm now impacted by that? I know that these are like sort of very, hypothetical situations, but these are, I think, are points that at some point are going to become real for us. And I'm just curious, like, where is the conversation right now with all of that? Where does that sit from a legal perspective?
So the law, despite now allowing possession, and really the key is also delivery, where they can where people can get delivery of these items. Despite those, the law is also clear that it does not permit any individual to use, and that's defined as smoke, vape, or aerosolize, I guess is how you pronounce that, cannabis items in a public place. So that would be, I guess, very similar to the public consumption of liquor outside of, a private restaurant or outdoor dining establishment. They define public place, I think it's a pretty good definition here, as any place in which the public has access that is not privately owned, or any place to which the public has access where alcohol consumption is not allowed, including but not limited to public street, road, thoroughfare, sidewalk, bridge, alley, plaza, park, playground, swimming pool, shopping area, public transportation facility, vehicle used for public transportation, parking lot, library, or other public building, structure, or area. So the law makes clear that this does not allow the public consumption.
Yeah.
Of
which is consistent with alcohol consumption. But here's a question, especially for those that are operating in urban areas. How are you going to support families in cities where you have parks and you now have these loosened regulations where people feel more empowered, because I mean, believe me, in terms of open container violations, it's like giving out speeding tickets at the Daytona 500. And police departments, honestly, they are not prioritizing those types of quality of life enforcement activities. How are we now going to deal with marijuana use in public spaces? And because it's not quite the same as alcohol use. I mean, it's kind of different, I mean. So how are we now going to treat that? I think, look, I don't think there's an answer here today, but I would be curious to know what our elected officials, how they're thinking about that for their municipalities, because in urban areas, we already have significant quality of life issues that we're dealing with on a daily basis. Adding the empowerment of marijuana usage to that is it's just it's going to have a significant impact on policing and enforcement and policy that at some point is going to have to be addressed.
I guess I'm going to jump in here, Chris. I think I think it's your opinion that it's different and or seemingly worse. Personally, I think pot use recreational is not as bad as overconsumption of alcohol publicly. And yeah, it does happen, and you got to deal with it the way you deal with it. And I think it's a moral compass that you're looking at that on more than a danger per se to others. To me, if somebody's having a beer versus somebody's token on a vape or a vape, it's neither here nor there until it becomes excessive, and at which point the cops are going to jump in either way because somebody's going to call them. And I guess, and you're not prohibited, like right now, you're not, at Jersey City parks at least, you're not supposed to smoke. And yeah, sure, people do it. But generally, if I think it depends on where in Jersey City, how much that's followed. The same with, I was having a glass of wine with the president of the neighborhood association in one of our public parks earlier this week because it's outside and we don't have backyards, so that's where we get together. As long as you're discreet, it's I don't think I don't see it any different than drinking. I don't know, that's just me. I know Vic has an opinion here too.
So we are moving on an ordinance to define cannabis as in the same category as smoking. So we have no smoking in our parks.
Right.
So right now our ordinance says smoking of tobacco products. So what we did is we also said tobacco products and cannabis products. So this, and the police have told us that this will at least allow them, when they see someone smoking a joint, to say, hey, you can't smoke here in the park, you got to move on. It's not going to be much more than that. The other aspect of, we have some drinking in the park, there'll be other consumption of non-smoking cannabis in the park. It's just, we're going to have to live with that.
I don't know if anybody saw the article and the video from Ocean City, Maryland earlier this week, where they're enforcing, you have to be careful with enforcement in equity, because they're enforcing just vape, period, of, people of color more so and aggressively, like, kneeling on people. So we don't want that to become a thing here, I hope, in New Jersey.
It's a very good point, because we've all heard the classic example of enforcement with the liquor, which is it's easy to enforce the guy with the brown paper bag, but not the couple having champagne in the picnic.
Yeah.
Or wine in the park.
Wine in the park, guilty.
In a Yeti,
Yep.
in an appropriately sized Yeti.
Yes.
I think also the point that Courtney makes is, that goes to the issue. I think, Chris, you said it. I mean, other areas of discrimination and stereotypes and expectations. And, And I do think, and Steve is certainly more the subject matter expert in terms of municipalities and zoning and things like that. But I think that a lot of this is going to come down to the, the gray areas and the outliers, right? Because the people who were inappropriately using marijuana were already doing it. And a lot of these more robust downtowns, they were doing it, I don't think that this is going to necessarily make that a significant difference such that those, who are not inclined to overindulge are going to just suddenly be walking down, falling into streets. But, I am interested to see how, to Steve's point, it is not permitted in public places. You cannot, be pushing your kid on the swing while, smoking on a joint. And I'm not trying to be sarcastic here, but I think that it's going to be something that, will hit a natural flow as it becomes more commonplace. And it is going to be something in terms of people's comfort levels and is it that they're concerned about secondhand inhalation of marijuana, or is it that there's a negative perception of people who, smells, things like that?
Yeah, the stigma. I don't, was it Bonnie? I promised I would get back this language, and I have this language here. The question was what the law says with respect to prohibiting retail establishments in places with liquor licenses. And here's the direct language. It reads, a cannabis retailer's premises shall not be located in or upon any premises in which operates a grocery store, delicatessen, indoor food market, or other store engaging in retail sales of food, or in or upon any premises in which operates a store that engages in licensed retail sales of alcoholic beverages. So it is a good question that was raised without an answer, which is how they define premises. I just checked, premises is not a defined term. Does that mean if there's a shopping center that has a spirits at the end of it, does that whole shopping center not be able to have any other space utilized by a retail establishment? It may. That's how I seem to read this here, but it's a very good question. I think it was Bonnie who asked it.
Bonnie, I don't have my MLUL handle is it handy. Is premise defined in the MLUL?
Maybe Moskowitz, I'm not sure, I'd have to look, but yeah, that was it, like lot versus premises versus, yeah.
Yeah,
so,
that's a little crazy, especially in
urban, tight.
Well, I guess not in urban because those are all individual lots.
Well, we have some buildings with multi-units,
yeah,
so downtown. So, but even a strip mall,
right.
Yeah.
It's not. There's no definition.
And do you think I wouldn't think the Cannabis Commission is going to speak to that because it's not really their thing. It's not.
I think it's a question, a comment when the regs come out. Was please define premise.
I'm not sure how you would interpret it the other way. It doesn't seem fair that the regs would prohibit that, but at the same time, what else could in or upon any premises in which operates a store? That in which means that it suggests it's only one component of the larger premises, right?
Yeah.
So I'm not sure how it could be interpreted the other way.
I would imagine there's probably some other similar, where premises needs to be strictly or narrowly, construed, how the case law sort of interprets that, it might lend some clarity.
Yeah, that one's weird. Like, why not?
And also, if something does go into, it's vice versa, then the landlord can never rent, and he might have an empty space, he or she,
right,
that just sits. But there was a great deli that could have come, or I guess we'll have to.
You know what? It may, at the same time, maybe it is going to be part of the regs, because where this falls in the law is in the section dealing with the commission's job to confirm the location of the proposed site when a retail business is seeking licensure. So it provides here an application for a cannabis retailer that is located in one of these locations shall be denied. So we'll see. Maybe there will be some regulations on that.
Okay, thank you.
Anything else?
This has been a good conversation, though.
Yeah. Look forward to the regs and digging in. I think we will have to do a part 2 to answer some of these questions, because it's so crazy that they want you to say something before there's any rules to say anything.
I think that was just a function of how quickly these had to be put together and not really, oh, we're putting the regs together and giving the same deadline to municipalities.
Yeah,
That it had to just be one of those, they didn't notice it or pick up.
yeah, because it should have been 100 and whatever days after the regulations were adopted, not after the law was
Correct.
adopted. Yeah.
I wonder if any town has fully adopted yet, or even had a first reading. Has Hoboken had a few?
Well, you know what, Bonnie, that's a great question, a great thing, because it's not as simple as just, okay, by August 21st, we'll adopt it. This is an ordinance, right? So it takes 2 meetings, and because it's really a zoning ordinance, it's got to go to the planning board in between. So
Right.
you're talking 3 meetings. So it, you know, to get it opted out by August 21st, you're talking about needing to start that process pretty soon. It's a very good point.
Mhm.
I know of a couple. Westfield just opted out. My town, Branchburg, opted out. I know several are opting out. I don't know of any of that have officially opted in.
Yeah, out is easier to,
Yeah.
you know, right.
In Metuchen, we had our first reading on opting out at our last meeting.
And
Yeah.
Jason, is the same analysis that it's easier to opt back in?
That's the hope, and yeah,
Yeah.
that's like I mentioned, that's what I wanted to hear again. So yeah.
Yeah, I think I was talking to Sheena Collum the other
Mhm.
day, and she said they're opting out, and I think a lot of the towns in the area are just going to opt out and see what the regs say, and then
That's what I think is going to be across the board.
yeah,
The challenge is explaining that to the residents who, you know, voted 70% for, that we're not actually necessarily opting out forever.
Right.
Just for
What-
the moment.
Yeah.
Well, what if you opt in? I made the suggestion maybe to opt in with very limited particulars in terms of zoning, and then judge it later.
Yeah, our ordinance,
I don't know.
no one reads it, obviously, but the very first whereas is that we're touching mayor and council are very much in support of
Yeah.
cannabis within the town. However, and then goes on to,
I think that's a safer way to go because
It's easy. It's not easy to sell that. It's still gonna be hard because you're right, Jason. Nobody reads it. They just see the headlines. You know, Metuchen says no to pot, right?
Yep.
But it is still easier to sell it that way than one town that I won't name, which got up there. And we don't care 80%. We were taking the moral high ground. Pot is bad. That's not gonna sit well, especially when that particular town, because you can tell who voted in the town. That particular town was 80% plus in favor of it.
yeah. Well, when they get elected out, they can always opt back in. All right. Any other questions, comments? I'm guessing nobody here has started any ordinances since, actual in ordinances. Yeah. All right. Well, so thank you so much, Jemmy and Stephen. We appreciate it. And we'll keep in touch. And the PowerPoint, Jemmy, if you don't mind, I will put up on the website, and this video will be up. And thank you and enjoy the beautiful weekend.
Thanks for having us. This was fun.
Thank you.
Thank you so much.
Thank you.
All right. Bye all.
Bye all.